Okay, welcome. There we go. Welcome to the Winter Inns of Court program. I'm Lisa Ritchie-Craig, and I am co-chair of the program committee this year, along with Kathy Horn. And we're very happy to welcome all of you to the Georgia State School of Law, their new building, which is just beautiful, and we're so happy to be a part of this event and this journey with them. I'm going to keep these introductions very, very brief because they have a lot to cover today. So I would like to just introduce our moderator, Summer Chandler, who is a partner at McCullough Raymer in the commercial division. She's also an adjunct professor here at Georgia State and a co-leader with the bankruptcy clinic here. So I know most of us know Summer, but it's really great to have you here and to be moderating this esteemed panel. I also want to thank Judge Stewart for being here with us today. He is the president of the American Inns of Court and the chief judge of the Fifth Circuit. We're very happy to have him in our presence today. Thank you so much for your time. Also, thank you to Georgia State for hosting us, and the reception will be immediately following the presentation to the doors on the left. Summer will give us some reminders as we near the end of the presentation today. And there will be a few minutes for questions and answers, so if you want to hold those to the end, Summer will give us all the rules. Thank you.
Great, thank you. So thank you, everybody. I'm so glad you could be here with us this afternoon. I'm very excited to be here with this fantastic group of panelists we have here. We have a lot we want to get through, and they have a lot of great information to share. But before I introduce them, I just wanted to share a few comments about the College of Law. This is a fantastic institution. They're really committed to both providing students with a solid understanding and grounding in the theory and the doctrine, that is so important for what we do, but also really recognize the importance of teaching their students practical skills and giving them those opportunities to understand how to apply that doctrine and that theory to actual real-life client situations. And, just one example of that commitment is the Bankruptcy Clinic, the Bankruptcy Assistance and Practice Program that was founded by Jessica Sino, and that I'm having the honor of teaching now. So just want to just commend the university for the work that they're doing. And with that, I want to introduce our panelists. Sorry, to make sure I'm sitting forward to make sure you can hear me. To my immediate left is Nancy Whaley. Nancy is a Chapter 13 trustee here in the Northern District of Georgia. She's also a Chapter 12 trustee. She employs 37 employees and operates a trust of over $75 million. So a lot of money flows through Nancy. She is actively involved in a number of professional organizations, including the Inn of Courts, the American Bankruptcy Institute, the Georgia Association of Women Lawyers, just to name a few. She is also retired from the Air Force Reserve. She retired as a lieutenant colonel in 2009. To Nancy's left is Rob Williamson. Rob has practiced for nearly 30 years. He is the managing member of Scroggins and Williamson. He specializes in business workouts and reorganizations and has advised clients in a wide variety of situations, and including debtors, asset purchasers, trustees, secured creditors, official committees, litigants in preference and fraudulent transfer actions. And he is admitted to the bars in Georgia, Florida, and West Virginia. To his left is Neil Gordon. Neil is a partner in the Atlanta office of Arnold Golden and Gregory. He is also a Chapter 7 panel trustee, and he specializes in the area of bankruptcy, business reorganization, fraud investigation, and creditors' rights. He also frequently represents other trustees and receivers throughout the country, including recently in a Delaware litigation that settled for approximately $40 million. Neil is actively involved in the leadership positions of a number of organizations and is a prolific writer and speaker. So we're fortunate to have these speakers with us here today. And we are going to be covering a wide variety of issues. There are a lot of things these speakers want to share with you. So my job is going to be to keep everybody on task and keep everybody on time and make sure we can share with you as much information as possible. So with that, I'm going to first turn it over to Neil, and he's going to talk a little bit about statutes of limitations in converted cases.
Well, thanks, Summer. The program is kind of a mix of trustee topics from 11 to 7 and 13. And although I like questions as I go along, I think the way we've structured this is to hold them to the end. And the first topic is going to be statute of limitations in converted cases. And one of the reasons that we're talking about this, and I speak about this frequently around the country, and I continue to see trustees that didn't read the memo, didn't get it. The U.S. trustees don't do it right. And so I'm either a terrible lecturer or it's just so ingrained that the opposite is what is true when, in fact, we're going to talk about what the law really is. And when you're dealing with deadlines, I always like to use this slide about the whooshing sound they make as they fly by. And so we hate them, but we need them. And so they're very important. When you get to this particular topic that we're going to talk about, almost everybody thinks they know what happens when a case converts from an 11 to a 7. Trustee is immediately appointed. And everybody thinks that if you're less than 2 years before the commencement of the case, but more than 1 year out, that you've just picked up another year for your statute of limitations. But the fact is that's not always the case. In many instances, there is no additional time. You're still within the framework of the 2-year period. And why is that so? Why is everything we thought we knew wrong? And if you look at the statute, here it is, you've all read it. 2 years after the entry of the order for relief, that's what 546A says, or 1 year after the appointment or election of the first trustee. So far, so good. But then it says under Section 702, and that's the problem. Because when a case is converted to Chapter 7, within a day or two, an interim trustee is going to be appointed. That interim trustee thinks, okay, I've now got another year to bring avoidance actions, but the appointment of the interim trustee doesn't trigger the year. The interim trustee is appointed under Section 701. As you see in the statute, it's Section 702 that triggers the additional year. Now, these are the 3 leading cases on this issue. Wow, it's jumping, isn't it? The Third Circuit was the first circuit court, but the Delaware court had already ruled a couple of years earlier that this is, in fact, the case, and the Third Circuit agreed. Then when you get to the Seventh Circuit case in 2013, which I call the Draymond case, this one was actually certified for direct appeal to the Seventh Circuit, so it went straight from the bankruptcy court to the Seventh Circuit, which caught me off guard because I was writing an article for ABI Journal on what was wrong with the bankruptcy court's opinion, and the Seventh Circuit ruled almost immediately, and I had to throw that one out. The bankruptcy court is a very good judge, Judge Barnes in Chicago. He had looked at this and he said, this doesn't make any sense. He says, it can't be that you appoint an interim trustee and you don't get an extra year. So he decided that, well, when does the interim trustee become the permanent trustee? And the answer, of course, is when the meeting of creditors concludes. If there is no election of a trustee, then the interim trustee becomes the permanent trustee. In the case that he was looking at, the interim trustee was appointed just before the 2 years was up and had the meeting of creditors after the 2 years and then became the permanent trustee and brought avoidance actions, motions to dismiss were filed, and ultimately he ruled that there was an extra year and got reversed. And he had this concoction. He said it just doesn't make any sense, so he came up with this scenario where if you have the meeting of creditors outside the 2 years, and that's when your permanent trustee goes into effect, if the permanent trustee is an elected trustee, then the elected trustee does not have an extra year. But if there is no election and the interim trustee becomes the permanent trustee, then there is an extra year. And that made even less sense. So that got reversed. Then you get to the what I call the Live Merschel case. And this is the slide that you see is actually what happened in that case. The trustee had plenty of time, but kind of blew it. So 13 and a half months into the case, it converts to a 7. That's plenty of time left to conduct a 341 meeting, conclude it, and pick up the extra year. Trustee doesn't do that. And part of the reason is because the principal of the debtor is not showing up, and so he doesn't have a witness. He finally gets the principal there. This is now August 30 of 2011, and so you're well within the 2-year mark. And he holds a meeting of creditors, but the principal is evasive. He hasn't produced the documents that were requested. And so the trustee should have concluded the meeting of creditors and picked up his extra year, but instead he continues the meeting. He could have concluded it and taken a 2004 exam, but he doesn't. So he continues it. He doesn't pick up the extra year. So he goes all the way, the 2 years passes on January 11 of 2012, still no 341, and there's still no trustee appointed under Section 702. So he's missed the 2-year mark now. And he finally brings, several months later, he finally brings an action to recover $900,000 from a company whose principal was also the principal of the debtor, the same person that was evasive and not producing documents. And so naturally he gets hit with the defense of the statute of limitations has run, you're out of time. And the court rules he was out of time, except for the fact that because the principal was so evasive and not producing documents, that he invoked the principle of equitable tolling, and so the trustee, despite himself, managed to bring the action. And this can also help you because sometimes you think, okay, my deadline, I'm the trustee, my deadline is, in this instance, case is converted July 2, 2013. Let's say that the trustee is appointed as interim that same day. And you say, okay, so now I've got to July 2 of 2014. But no, you actually have to August 2 of 2014. You actually have an extra month because you didn't become the permanent trustee for another 30 days. And so here's the timeline on this. On an actual case, that was Judge Bonnefeld's case. And I know he hates it when I talk about this situation, but Jason Petty was appointed as the interim trustee, I think, 2 business days before the 2-year mark. And so he had been to some of my seminars, heard me talk about this. He calls the U.S. trustee and says, what am I supposed to do? There's no time to do a preference analysis or anything else before the time runs. They said, oh, no, you've got another year. These were the attorneys from the U.S. trustee who at the seminar I had done 2 months earlier explaining this, but they still didn't understand it. And so he contacts me, and we quickly filed over the Labor Day weekend, we quickly filed a motion for an extension of the statute of limitations deadline. We got an emergency hearing before the court, and the court ruled that in the 11th Circuit, at least, the court believed it had the authority to extend it. Ultimately, and Jason did not determine there were any avoidance actions to pursue, and so it was never tested, which was probably fine with the court and everyone else because this is really kind of novel territory. And so how do we know when it's been concluded? The rules were amended, and Rule 2003 was amended on December 1, 2011, so that there has to be written notice specifying the day and time to which the meeting is adjourned. That has been the practice as long as I can remember in the Northern District of Georgia, but it was not nationally the practice. You had many districts where it was just stated orally at the meeting of creditors, and sometimes it was ambiguous and you couldn't tell. So now we're going to move on, Summer, to Nancy. I'm passing the clicker.
Yeah, so now Nancy is going to talk to us a little bit about the role of the Chapter 13 trustee with respect to avoidance actions. I think certainly unless you practice in the consumer space, you may not necessarily associate the Chapter 13 trustee with avoidance actions.
Thanks, Summer. One of the things to think about is the purpose of avoiding a transfer is to benefit the unsecured creditors. And so whether it's in a Chapter 7 or a Chapter 13, the purpose remains the same. However, there are more challenges for a Chapter 13 trustee than a Chapter 7 because obviously we do not stand in the shoes of the debtor. So when we look at it from a Chapter 13 trustee or Chapter 13 perspective, we're trying to accomplish 2 things when we examine a case and there's a potential avoidance action that can take place. Is one, protecting the unsecured creditors, and we look at this by, one is the debtor meeting the best interest of creditors test, which I'll talk about in a second, and then 2, preserving the asset or the ability to a future avoidance action for a Chapter 7 trustee in the future, if need be. So what happens in the couple challenges that we have in the 13 is first under 1307B, because in Chapter 13, the debtor has the right to voluntarily dismiss a case at any point. And so Chapter 13 trustees sometimes are very hesitant to become involved in either any kind of sale or any kind of avoidance actions because we can be in the midst of it, spent a lot of time and effort into it, and then the debtor voluntarily dismisses. The second is that in a 13, the debtor... in Chapter 13, under 1306B, it provides that property of the estate, that the debtor remains in possession. And then 1327 provides that except otherwise provided in the plan, the confirmation order, the property of the estate vests in the debtor. In the Northern District of Georgia and in the Middle District of Georgia, both districts have plans that provide that the property does not vest in the debtor until dismissal or discharge. In the Southern District, it does provide that the property vests in the debtor at the time of confirmation. And each one of those can bring up their own little nuances when a trustee tries to step in and make any type of avoidance, take any type of action to avoid any type of preference or a fraudulent transfer. So what we have done over the years is we've realized that rather than stepping into the shoes and actually taking the avoidance action, is to try to resolve the action with some type of settlement or tolling to preserve something that's going to happen in the future. Because in the best interest of creditors test, let's see if we, I think our slides may have gotten out of order here. The best interest of creditors test provides that the debtor shall provide in their Chapter 13 plan that unsecured creditors receive as much as they would in a Chapter 7. So of course this is a hypothetical liquidation that we go through in a 13. So when you're looking at an avoidance action, you're trying to determine what the value of that avoidance action would be if a Chapter 7 trustee had the case and was attempting to avoid the transfer. And sometimes this can be a little bit difficult because it is hypothetical. The other part that's difficult in a 13 is you're not actually going to go through the steps of avoiding the action. And so you don't know some of the litigation expenses that could come into play and what would end up bearing the true benefits to the unsecured creditors. The other challenge that we have, and this is something that we have, is under 362B, and most of you all are all probably familiar with 362B that changed under BAP CPA. This is something I will tell you that we had not really considered until within probably the last 6 months. And we had, and how this impacts the trustee's potential action for an avoidance or liquidation issue. So what happens under 362, as you know, if a debtor has a previous bankruptcy case that was dismissed within 1 year of filing, they have the automatic stay for 30 days. And then they can extend the automatic stay. However, if a debtor has two previous bankruptcy cases that were dismissed within the filing of the bankruptcy case, there is no automatic stay, and the debtor has 30 days to impose the automatic stay. So historically, this has always been an action that the debtor has pursued and taken because they have a vested interest in imposing the stay so they can keep the house, keep the car, and reorganize in a Chapter 13. Well, we had a case just recently in which 362D 4A was applicable because the debtor had two previous bankruptcy cases that were dismissed. The debtor had equity in the property. The debtor did not impose the automatic stay, though, within 30 days because the debtor was taking the assumption that they could work something out with their creditor. We had not had the 341 yet, and the creditor filed a motion under 4A2i requesting the court to enter an order confirming that there was no automatic stay after the 30 days had expired. The court entered the order. During that time period, we discovered that there was significant unencumbered equity in the property. So we started to examine the case and realized that this was a big uh-oh for us because now all of a sudden, if the debtor wanted to convert, there was no automatic stay. If the case converted to 7, the creditor was well within their way of foreclosing, and what would happen if the Chapter 7 trustee got the case. So we filed a motion requesting for the stay to be imposed under 105. There were quite a few hearings that went back and forth. At the end of the day, the judge did enter an order under 105 imposing the stay and converted the case to Chapter 7. But what that ended up, the same thing could have happened, though, as let's say the situation where the stay was not imposed and we realized that there was some type of avoidance. Maybe there was a mortgage that was not perfected, a car title that was not perfected. And if the stay was not imposed, what would that, how would that inhibit our ability to take any type of avoidance action or preserving that asset for the unsecured creditors if the case converted? So now we are in a process of examining within the first 30 days whether or not we need to examine the case and file a motion to impose the stay if the debtor is choosing not to, so that we can preserve that asset. So every time you think you have something figured out, you realize that there's a new nuance to look at. And historically, debtors' attorneys have been the ones that have filed those motions, so it's not been an issue. Some other areas, though, and so what I thought I was going to do today, and I mean, we take the same actions as a Chapter 7 trustee would, you know, whether they're under 547 or 544 or 548 or under one of the fraudulent conveyance actions under OCGA. So we would take the same actions as a Chapter 7 trustee, but again, because the debtor can voluntarily dismiss, because the debtor is meeting the best interest of creditors test by proposing to pay their unsecured creditors whatever that percentage would be, and many of these cases are 100% cases, we don't have an interest to really actually avoid the transfer. So what we have more of an interest in doing is preserving the transfer. So I thought I would just tell you some cases that we've had to show you how this plays out in a 13. Debtor files a case in July of 2015, and the debtor's mortgage company is Nation Star. It's their primary residence. However, the debtor's current on the mortgage, and the creditor does not file a proof of claim. And within the Chapter 13 plan, there's no reorganization of any type of mortgage arrears, obviously. And in the Northern District, most of you know, the debtor pays their ongoing mortgage payments direct. They're not paid through the Chapter 13 plan. The debtor's plan proposed 100% dividend to the unsecured creditor. There's a motion for relief filed in the bankruptcy case, and the creditor gets stay relief to go to state court because they need to reform their security deed and note. What happened is it was transferred, the original was lost, they had a copy, and so they went to state court so that they could record the copy of the deed to secured debt. We become more aware of what's going on in the case and the state court action. We ended up settling for the trustee not to step in and oppose the action in the state court. We settled it with the mortgage company, and the mortgage company paid into the Chapter 13 plan the amount that unsecured creditors would receive in a Chapter 7, and that was an instant distribution to the unsecured creditors, and the mortgage company did not take any distribution in the process. In most of these, we bring a motion under Rule 9019, notice all the parties, and reach that kind of settlement. So, and we see that a lot with unperfected mortgages, whether they're filed in the wrong county or there's some type of error in the recording instrument. And so a lot of those, that's how we settle them, either with the mortgage company, the title company, sometimes the closing attorney, but we'll ask for them to pay the lump sum into the bankruptcy case to the unsecured creditors. Another case that we had, and these are just various examples, we have a lot, but we had a case that the debtor filed in January of 2015. It was the debtor's second case within 12 months. What we discovered, though, at the meeting of creditors is that the debtor had transferred a Rolex watch, which he valued between $16,000 and $18,000 before the filing of the bankruptcy case. The debtor testified that he gave it to a third party that was unknown in exchange for a 1998 Volvo. However, before he was able to record the title on the before the recording of the title on the Volvo, the debtor sold the Volvo to a third party and received $1,000 for the Volvo. The debtor then used the $1,000 as a down payment for a 6 Series BMW, which was financed by a creditor. And then the debtor files bankruptcy to pay this car within the context of the bankruptcy case. So there's a lot of bad faith, and all of a sudden the debtor has amnesia and cannot remember any of the parties. One of them's in a parking lot. He doesn't remember exactly what the Rolex, what it looked like, and a lot of issues there. So what we did in that particular case is we filed a motion with the court explaining all the situations, that there was not a party that we could go find to undo the transfer, even if we wanted to step in and try to avoid the transfer. And so we entered into an agreement filed a motion with the court, served all the appropriate parties, and what we did is we preserved a future trustee's right to pursue the debtor for the value of the transfer, which the court would determine at the time of the challenge, and it also preserved the trustee's ability to seek equitable remedies based on any of the transfers. So sometimes we have to get creative in what we're asking, but we really are trying to preserve something for that Chapter 7 trustee to go after, because in
How
this...
did that case get confirmed, of all the bad faith you're talking about?
Well, he proposed 100%
good
dividend to his...
question.
I know, he proposed 100% dividend to the unsecured creditors, and sometimes it's easier to confirm a plan, or the court sometimes is going to be more inclined to confirm a 100% plan and give the debtor an opportunity to rehabilitate some of those bad actions.
Well, just so you know, we're waiting with open arms in Chapter 7
Yeah.
for you to send us those cases.
Send
You
you those
appreciate
cases.
her preserving those for you, I'm sure.
A lot of the cases, though, the way that we reserve them, we had a case in which a debtor inherited property. It was located in Mississippi, inherited the property from her mother. She received 50% interest in the real property, and 2 weeks before she filed her Chapter 13 case, she transferred the property to the cousin. The debtor provided proof, and the property was valued. This was a low-value case. It was about $22,000. The debtor amended her plan to provide a 50% dividend to her unsecured creditors, which would equate to her equity of $11,000. In that case, we filed a motion to extend the time to object to the transfer of the property pursuant to 11 U.S.C. 544, 548, 550, and OCGA 18277. And the court entered an order requiring the debtor to pay the unsecured creditors $11,000. It was not modifiable. It told the time to allow the Chapter 13 trustee or any future trustee to avoid the transfer, and extended the time for any type of avoidance action to 2 years beyond the dismissal or conversion of the case. The order, then we took that order and recorded it in the property records in Mississippi, so that if the holder of the property attempted to make any transfers of the property, any bona fide purchaser would be on notice that there could be a future claim against the property if the debtor didn't pay out the case and receive a discharge. A similar case, though, which was higher value, is at the 341. We discovered that that a debtor inherited a piece of property with their two siblings, valued at $276,000 unencumbered, and the debtor stated that she transferred her interest to her siblings because that was the belief that she thought her mother wanted to do, or wanted to have happen. However, there was no will, and she was not willing to. Sometimes we can get the family members to undo the transfer and bring the property back into the estate, but this particular time they were not willing to. So the debtor amended the plan to 100%. We filed a similar motion. The debtor had a non-modifiable plan that she would have to pay 100 cents on the dollar, and again we entered that order into the property records in DeKalb County. Am I out of time?
About another minute.
Okay, so just real quick, another case, though, that this is an example where it doesn't work out, is we had a debtor that received $269,000, gave $85,000 of it to family members, $65,000 to her mother. We got in, staged everything, was getting ready to go after it, and the debtor's case got dismissed because she stopped making her plan payments. And those are some of the challenges that you can have in a 13. There's another case where the debtor is actually taken.
But that case was dismissed?
It was dismissed.
So why wouldn't that have been converted so that creditors could benefit from avoiding the transfers?
Well, because it's very hard if the debtor does not want to convert the case to Chapter 7.
Well, I understand.
I mean,
It's the creditors I was thinking of.
Right, but if a debtor can voluntarily convert to a Chapter 7, but unless you can really find, it's going to be hard. I mean, I think especially in the Northern District of Georgia, it's going to be very hard to get a judge to order a debtor into a 7 when they do not want to be in a 7 from a 13, when they can voluntarily dismiss. So even if we file a motion to convert, the debtor could voluntarily dismiss as an absolute right. Another case just recently, this is where the debtor is actually pursuing an action. Some of the parties are in in the audience today. The debtor transferred the house to his wife, and there was a Chapter 7 where the Chapter 7 trustee, I believe, discovered all of this transfer, and the debtor converted to Chapter 13. The debtor's wife is willing to refinance, take out about $28,000 to pay off the creditors. The debtor has gotten the unsecured creditors, there are 2 unsecured creditors, to compromise their claims to 70%. And so what will happen is the debtor's wife will refinance, pay the money into the case. The 70% will be paid to the unsecured creditors. The attorney's going to subrogate his attorney fees till after the unsecured creditors then have been paid in full through a stream of Chapter 13 plan payments during the life of that case. And the Chapter 7 trustee is signing off on that order. So those are just some examples of how we'll work with avoidance and potential fraudulent transfer or preference actions within 13.
And it's interesting, there are lots of different options that I guess are very fact-specific, depending on what you're dealing with.
Yeah, and there are 2 cases that are in our slides that are on this kind of related issue. One is Nasuti versus Dolan and N. Ray Leatherwood. Very different fact patterns, but are both dealing with avoidance issues in converted cases between 7 and 13.
The McDonald case is the trustee didn't have a chance to file the avoidance action. It went to a 13. The 2 years ran, then it got converted to a 7. Then the trustee tried to use equitable tolling, and Judge Brizendine said, no, you can't. You knew about it. So because of that case, even if I've only been the trustee for 2 months, I rushed to get an adversary filed before a case can get converted, just to be sure that nothing happens. I mean, I don't know what happened in that case where there was no tolling agreement or anything else that happened, but things happen. Yeah. And we're fiduciaries, so I always rush to do that. Even if the case ends up being converted, the actions usually stayed in the 13. Every time it comes back, but you don't know when. But it's a...
It'll be interesting. We'll talk about that again when we talk about the inquiry of the duty to inquire as to whether to bring an action and under what circumstances, because when you're pressured with time, but then you're, Yeah,
and we're pressured with time.
Yeah, I know.
This hour.
I know. Right. All right. So, Rob, I'm going to turn it over to you. You represent Chapter 11 trustees frequently in various parties in Chapter 11, so you're going to focus on the Chapter 11 context.
Yes. Summer, thanks. And we also do a lot of work for Chapter 7 trustees, and frequently we'll have liquidating plans confirmed and represent liquidating trustees. So most of these principles apply across the board. So I'll wear my hat as counsel for a trustee. And I'm going to try to, there's a lot of kind of a hodgepodge of different concepts here on using avoidance actions defensively. I'm going to try to hit 3 or 4 of them in the time that we have. There have been some changes in the law in recent years that sometimes help and hurt efforts to use them defensively. As an initial matter, as Neil pointed out, everybody probably knows under Section 546 of the Bankruptcy Code, there's a statute of limitations which limits the time period within which avoidance actions can be brought by a trustee or even a debtor in possession if it's still a debtor in possession, or certainly a Chapter 11 trustee. And a question arises oftentimes, particularly in the more complicated and larger cases, the case will be in bankruptcy for quite a bit longer than those periods of time. And sometimes either through just the time pressure of getting the case, moving it along to a certain point to get a sale accomplished, and then converting it or having a liquidating plan, or perhaps discovery hasn't been done, or facts come to the attention of the trustee after the statute is run. And the question becomes what can be done at that point in time. Of course, everybody probably knows that a statute of limitation is just an affirmative defense. It has to be pled. If you're in state court, if you sue somebody after the statute of limitations under a cause of action that's time barred, if the defendant doesn't plead that as an affirmative defense, in most states, the plaintiff can still go forward. So you still have, the claim still exists, it just can't be enforced is the purpose of the statute of limitations after a certain point in time in order to support principles of finality. Interestingly, in bankruptcy, and I guess it's really just picks up on common law principles, the courts will generally allow a trustee to use an avoidance action defensively with respect to a claim that a creditor has in the case. They can use 502D, which basically, I'll paraphrase it, provides that the bankruptcy court shall disallow any claim of any entity from which property is recoverable under, and it cites the turnover sections and the avoidance recovery sections, 542, 543, 550, or 553. And if they're a transferee of an avoidable transfer, unless the entity has paid back the amount owed or turned over the property. And that's a section of the code that was codified in the new code, which carried forward from the old Bankruptcy Act, which was intended to support the policy of enforcing court orders. The basic idea is if you have an order or a judgment against somebody that is supposed to turn over property to the estate, that until they comply with that order, they shouldn't be allowed to participate in a distribution in the case. And let's see, let me see the flicker there.
Yep.
Yep, I cited a case here, the McKenzie case out of the Sixth Circuit, which I think is a recent decision which has a good discussion of using an avoidance action defensively. In that case, the statute of limitation had passed for bringing any kind of avoidance action. And interestingly, it was a law firm that was the creditor there, and they were trying to enforce their claim, pre-petition claim for fees against the debtor, and there had been an effort to assign a security interest in some assets of the debtor prior to the filing of the case. And so most of these come up in the context of an objection to claim, but this one interestingly came up in the context of a motion to lift stay. And basically, the trustee, in response to the motion to lift stay, pled under 502D that he had a prima facie case using the strong-arm powers under Section 544, standing in the shoes of a hypothetical creditor to avoid the security interest that was allegedly pledged to the law firm prior to the case. And of course, as you might imagine, the firm contested that on the grounds that the trustee couldn't use the strong-arm powers after the statute of limitations had passed, and they had no ability to come in and challenge the validity of the security interest that way. And the court disagreed and held that the trustee could and allowed the trustee to use the 502D of the code to object to the claim, the secured claim of the firm, and basically said that they didn't have a secured claim, and that was a situation where it allowed funds to be available for other creditors in the case. Otherwise, the firm would have basically taken all of the assets of the case. And that's as I mentioned, a general common law rule, and you'll see that even under Georgia law. In many states, I think most states probably have the principle that even if you've got a time-barred claim against somebody, if you were sued, usually you can raise that by way of a set-off defensively, even though you're not allowed to get an affirmative recovery. You can use it to defend against a claim that's filed. And that's, you see that in some of the case law if you're doing any kind of debtor credit or litigation. As I mentioned, most of these cases arise when you go through the reported decisions in the context of a claim objection. And you know, sometimes you may ask, well, I mean, it's not always a situation where somebody has dropped the ball and just missed a deadline. Sometimes some of these cases are situations where it really doesn't make sense to file an adversary proceeding and go through all the hoops of getting a judgment. It's easier to plead your prima facie case in a claim objection And you still have to present evidence. Most of the courts say you still have to present evidence to actually establish the avoidability, and you have to establish your preference case or whatever type of avoidance actions you bring. But if it's a situation where you don't think the other party you'll be able to collect from them, sometimes it comes in cases where you have a foreign creditor and it's going to be very difficult. Maybe it's a nation that's not a party to the Hague Convention, and you're going to have a difficult time collecting, but yet they've got a large claim in your case that you need to basically deal with and address as a trustee. You might consider using the avoidance actions that way in a defensive manner. Another point that I'll make in this area is that, and this has come up from time to time, where people you'll have an assignee of a claim, and the assignor actually may have received some preferential transfers or other avoidable transfers prior to the case, and the assignee tries to come in kind of in a make a holder in due course type of argument that they should be allowed to participate and receive a distribution on the claim, that they weren't the ones that received the preferential transfer. There are a number of cases that have addressed that in recent years, and the general rule, not surprisingly, is that the assignee of the claim takes it subject to 502D objections. So if the original holder received an avoidable transfer that has not been paid, you can use that as a basis to object to the claim of the assignee. And if you're representing claim traders and you're out there buying claims, you need to be aware of that and make sure that you know that you take it subject to kind of the caveat emptor principle and do some due diligence there. Another interesting point is that under 502D, it's not just a reduction. If you're able to establish a 502D objection and establish that the other party, the creditor, received an avoidable transfer in any amount, it's not just an offset against the claim that's being asserted by the creditor. They have to pay the amount avoided into the estate before they're allowed to participate at all in the case. So sometimes you'll have a big disparity. You'll have situations where you have a relatively modest preference, and for whatever reason that creditor is not able to pay that back or unwilling to pay that back, and you can knock out the entire claim of the creditor under those circumstances. It doesn't just reduce the amount of the claim. Sometimes people think it's just an offset or it's just a reduction of the amount of the claim. There have been some there was a recent amendment to Rule 3007 that deals with claim objections that now, I think that was about 5 or 6 years ago, which the amendment was made to, I really don't have any slides, so y'all can switch those lines if you want. To provide that you cannot include a relief that is supposed to be brought in an adversary proceeding under Rule 7001 in a claim objection. And so the courts are struggling somewhat with the fact that under 502D, that's under 502, that's claim objections, but you're actually alleging a cause of action, a prima facie case that if you were trying to get an affirmative recovery, you would have to actually plead it as an adversary proceeding and file it as an adversary proceeding. One case indicated that you can actually bring the 502D objection as a claim objection and sustain an objection to the claim, and that doesn't foreclose you from later filing the adversary proceeding to file the preference action. So
that's what I've been doing. I've had several of these where they were in Chapter 13, statute of limitations ran, the case gets converted to a 7. I see facially defective mortgages. They always file claims in the 13, even if they don't in the 7. I object to the claim. I set up a bona fide dispute. I sell the property under 363 B and F, and then I've got the money, and then we resolve the claim objection. And I've never had one mortgage lender raise the issue of the statute of limitations having run, which always surprises me, but they've never even. Now, of course, I shouldn't have said anything, but...
well, Neil, we're going to let you talk a little bit more about time.
You're going to pass me that clicker and we'll move along. Okay, now, everybody in this room who's not a law student has used Section 548 to reach back 2 years. You've used Section 544 to reach back whatever your state's fraudulent transfer law is. In Georgia, 4 years under our version of the UFTA. But how many of you have ever reached back 10 years or longer other than, say, using the discovery rule? Probably no one. I mean, I have, but probably no one else. And that is the subject of the next topic. So 544B1, and we've been talking about this, basically says that the trustee can do whatever under applicable law a creditor holding an unsecured claim can do. And oftentimes, surprisingly large, and maybe not surprisingly, but a large number of times, we have a federal creditor, a governmental creditor. It's usually the IRS, it can be the SBA, it can be an environmental agency, it can be anything. And you'll see on a later slide, there's about 8 cases from around the country that have all recognized that the trustee can stand in the shoes of the governmental creditor and reach back. It can be 10 years, it can be longer, it can be shorter. And the one case that went against it, Judge Jacobitz in New Mexico, he's always bragging to me about what a great law clerk he has, and she is. And she went into this opinion, this Vaughan case, into the history of British common law and what the King of England used to be able to do, and she said that the government of the United States essentially inherited the role of the king, and that's the IRS, and so no time runs against the king, but it does against the trustee. That was his conclusion, and so he would not extend it out. In response to that case, Judge Barnes in Chicago on New Year's Eve, I don't know what he was doing that he's releasing his opinions on New Year's Eve, but anyhow, he released this Kaiser opinion, and he disagreed with Judge Jacobitz and said, yes, there's the plain meaning of the statute says that if the IRS is the unsecured creditor, the trustee can stand in the shoes of the IRS as the golden creditor. Judge Frank in Pennsylvania said the same thing in the Polachuk case. Kaiser was very instructive because he went into great depth about the tax code and explained how it actually works for the IRS. And so the IRS is 3 years from the filing of a tax return to assess tax liability against a taxpayer, and 1 year thereafter to assess tax liability against a transferee. Then the IRS has 10 years to collect. And if a tax return hasn't been filed, the assessment can be made at any time. So theoretically, you're talking about a very lengthy period of time that is potentially reachable. And that's the best case that actually explains it. And as to Judge Jacobitz's Vaughan opinion, he says, look, 544 trumps the policy arguments, plain wording of the statute. And here is the list of the other cases, or at least some of them, and they're from all over the country that have also recognized the right to stand in the shoes of the governmental creditor. These are all IRS, and you can see there's 5 there. And then one other case, GI Holdings, a New Jersey case, allowed the trustee to stand in the shoes of a federal environmental agency and reach back 10 years. This case, Judge Laney's case from Valdosta, that's actually me as the trustee plaintiff in the case. He allowed us to, on a motion to dismiss, which he denied, he allowed the trustee to pursue Federal Debt Collection Procedures, not Practices, Procedures Act, and reach back 6 years. And that action is still pending, but that's a reported decision. And under this statute, there's a six-year reach back on fraudulent transfers and a 2-year look back on insider preferences. IRS was a large claimant in the case, both on the petition date, which is the day you're supposed to look, but also on the transfer date. These are a list of cases that have also recognized the trustee's ability to stand in the shoes of the governmental creditor for purposes of the Federal Debt Collection Procedures Act. And so these were cases where there were 6-year lookbacks, and you'll see the bottom case there. It was the SBA was the creditor, and some of you only deal with cases where you wouldn't have small business administration in it, but trustees have cases big and small, individual and business, and we see the SBA, and I do ask at the 341, I always ask, well, have you transferred money or property within 4 years of the bankruptcy? And the answer is always no, even if they had, a week before. But the answer is always no. And I say, how about 10 years before? And they always say no. And I'm thinking, I know that they don't remember what happened 10 years before. But it's something I feel like I should ask anyhow when there is a governmental creditor. Now, here's the timeline that ties together the two topics that I spoke about. The first topic, of course, was that the 1-year period isn't picked up unless the interim trustee becomes the permanent trustee before the 2 years is up. So let's take this hypothetical. 2005, April 1, 2005 is the initial transfer date, a long time ago. Chapter 11 gets filed just short of the 10 years on February 27 of 2015. The 1 year goes by. And then comfortably, still a lot of time, the interim trustee gets appointed because the case is converted to a 7. And then before the 1 year, before the 2 years runs completely, he does conclude the 341 and picks up the extra year because he's now the permanent Section 702 trustee. And as is typical, almost the entire year goes by before the lawsuit gets filed to avoid the transfer against the initial transferee. And then I'm figuring maybe one appeal and you get a final judgment, and you're now in August 30th, 2021, you get your final judgment, and then under Section 550F of the code, whether you realize it or not, there's actually another year to then sue for recovery. Although most people include avoidance and recovery in the same lawsuit, the code doesn't require that. And so then you bring the action, and this is a whole other topic that we're not doing in this panel that I usually speak on, involving 550F, which is why I've done this. So now you have an action that is brought 17 years after the transfer and 6.5 years after the petition date, and it's timely. And just think about that. There's also other statutes that are continuing to be passed by Congress, and Georgia adopted the Deficit Reduction Act, which has a 5-year reach back if the state of Georgia is a creditor. And so not every state has adopted it, but some have. And I think that's one more topic with the 10-year reach back is self-settled trusts or similar devices. And the bottom case is one of mine, Gary Marsh, I saw up there. He's involved in that case too. This was added by BAPSIPA 548E1, a transfer by a debtor to a self-settled trust or similar device with actual intent to hinder, delay, or defraud. And it does, believe it or not, come up. And I noticed that the new forms, which went into effect December 1 of 2015, the new Statement of Financial Affair form actually has the question on there. Have you transferred to a self-settled trust or similar device within 10 years, the last 10 years? I was really surprised that was actually in the schedules now. I want to just briefly tell you what happened in the Huber case, the Washington case, because that's a very interesting case. I don't want to talk about my case. But in both of these, the efforts to dismiss the lawsuit were denied by the courts. But there you had an individual in Washington State who had personally guaranteed dozens of real estate loans. And so he decides to do his estate planning right after Lehman Brothers collapses in September of 2008. That's when the estate planning, of course, makes sense. And so he creates this Alaska Domestic Asset Protection Trust, and he pours into it interest in 20 entities, shopping centers, developmental projects, homes, corporations, so on and so forth. And about 98% of the assets were located in Washington State, and the other 2% in Alaska. And he argues that it was legitimate estate planning, and Judge Snyder in the Huber case says, first of all, I'm going to apply Washington State law, and they have a strong public policy here against self-settled asset protection trusts, and he grants summary judgment for the trustee. And what he says is that estate planning and the actual intent to hinder, delay, or defraud creditors are not mutually exclusive, which is great. And so this is the other 10-year reach back that is actually in the code explicitly now. Okay?
Okay,
I'll
great.
pass the
Thank
clicker.
you, Neil. Thank you. So there's just one other issue. Rob, you want me to?
Yep.
I'll just
sure.
tee this one up.
I'm not good with technology.
One issue that I just wanted us to have a chance to have the panelists maybe touch on. The ABI, I think probably as most of us know, the ABI put together a commission to study the reform of Chapter 11. And after a lot of work by a lot of folks, came up with several recommended revisions to Chapter 11. And A few of those related to avoidance actions. And as part of the report, the Commission noted that it reviewed the testimony from various public hearings, which evidenced strong frustrations with preference law. Witness testified that some trustees pursued preference actions with little diligence and without regard to the merits of the underlying claim. They suggested that, at least from an outside perspective, some trustees appear to file preference actions not necessarily to recover the alleged preference, but to exact a settlement payment. Now, I'm sure neither of you would ever do that. And so, oops. Oh, sorry, I killed it. The recommended change, now it's not responding, that the Commission suggested is that the trustee should be precluded from issuing a demand letter or filing a complaint against any party for an alleged claim under Section 547 unless, based on reasonable due diligence, the trustee believes in good faith that a plausible claim for relief exists against such party under Section 547, taking into account the party's known or reasonably knowable affirmative defenses under 547C. So, Rob, why don't you start off? I just want to get your response to that, your thoughts on that. What does that mean? Is that a significant change from where things are now?
Well, you know, I don't think it's really a significant change. I know we certainly understand the frustration. I mean, preference actions are oftentimes the only exposure a small business ever has to the bankruptcy system. You can ask almost any client you're defending on a preference defense, and they may have been hit with another one before, and that may be the only time they've encountered the bankruptcy system.
They hate us all, don't they?
They do. They think it's all rigged against them. And I remember the late Judge Kahn told me several times that he thought the preference laws were the worst provision of the bankruptcy code as far as the public was concerned. That was the perception, and I think to some extent he's right. I think we already have. I tend to be, although I tend to feel like we've already got rules and procedures in place to police that type of thing. And you know, the judges are already armed with you know, Rule 9011 and other tools to handle the egregious cases that if people bring them before them. And as Neil pointed out, oftentimes a trustee gets appointed. They're under a lot of pressure. They have scant documentation or evidence regarding transfers. They might have a check register and don't really know what the payments were for. And so this is kind of amorphous to me. Reasonable due diligence, reasonably knowable affirmative defenses. I think it kind of comes into the you know it when you see it. I thought Judge Drake's opinion on that in the Leeds case was a good, well-reasoned decision, and you know, basically said that those are affirmative defenses, and normally you don't have to, with respect to affirmative defenses, you know, obviously they have to be pled in good faith, but you don't have to go in and do all of your discovery beforehand. And if there are egregious cases, I think people should bring those to the courts, and you know, a couple of sanctions, I think, will send the message to people that they need to comply with the rules we already have.
Neil, why don't you give us your reaction, and should there be a distinction between doing your reasonable due diligence for making the claim versus known or reasonably knowable affirmative defenses and confirming whether the potential defendant has a defense?
You know, it's hard to answer. Sometimes you come into a case as the trustee, you have a month, 3 weeks. I mean, you don't really have time to do the due diligence, or the case is so complicated by the fact that there are no valuable records that a normal business would keep, and sometimes that's by design, and sometimes it's by negligence. But you can't get your hands on valuable records. You can't get your accountant in there to analyze them. And so sometimes you do just sort of shotgun all the actions out that you identify, and then you continue as you get information from the defendants on their affirmative defenses. You start dropping the lawsuits. You start dismissing them. I have no problem dismissing a lawsuit. I'm not looking for any sanctions. I'm not looking. I'm less concerned about 9011 because I think Judge Drake had ruled in another case, and it may have been Isaac Lesko, that 9011 doesn't apply to the affirmative defenses. Your investigation has to be reasonable as to whether the avoidance action is supportable. Is there a preference, not whether there are defenses to the preference, affirmative defenses. So I'm less concerned than I am with, say, 28 U.S.C. 1928, which talks about continuing an action that you've determined is no longer valid.
Right.
That would be of more concern to me. But I don't know anybody that would want to continue that. So I'm sure some do, but the trustees aren't doing. I don't think are doing that. You just don't always have the time and the ability. Right. But if I had in advance satisfied myself that there were valid affirmative defenses and the action wasn't valid, I wouldn't bring it.
I think I'd like to see 547C9 has a defense to preferences that where the total amount of the transfers in aggregate are less than $6,225. I've actually used that before. But I'd like to see them raise that. I think that's too low. When you see someone bringing a $10,000 preference action, I mean, that's a lot of times you scratch your head and say, is that really going to benefit the estate much? And so if you put that up to $15,000 or $20,000, I think that would help some. The other thing is that I think in part what makes these unpopular the cases we've heard about, and thankfully, most of them are not in Atlanta. I've seen a lot of them in New York and Delaware, so we'll blame them. Where a case looks like it's administratively insolvent or likely to be administratively insolvent, and the avoidance actions from the outside appearances are really just being brought to benefit the professionals or make sure the professionals got paid and other administrative claimants in the cases. And I've actually seen cases where the court put a stop on that. I represented a couple defendants in I think it was the West Point Pepperell case up in the Southern District of New York a few years ago. And there was an order entered in the case that stayed all the existing preference actions until they could look into allegations that the case was hopelessly administratively insolvent. There was going to be no benefit to the creditors, and whether a dismissal, whether it was likely to be dismissed, and I think ultimately it was dismissed.
Interesting.
Yeah. So.
Interesting.
That sounds like what Judge Kahn used to say about bankruptcy being a process where all the assets are marshaled, they're liquidated, and then the proceeds are divided equitably among the professionals.
All right, well, I want to make sure we open it up to questions. So does anybody have a question they'd like to ask? Sir.
This question is aimed at the entire panel. The daily bankruptcy report this morning shows what I'm doing in my department. Jim. Had an article about the use throughout other jurisdictions, not ours, not Georgia, of an injunction to assist a trustee or debtor in possession in an avoidance action to recover either a fraudulent conveyance or a post-petition transfer pre-judgment. I'm wondering whether anybody on the panel has seen such a case or whether they've ever used that as a trustee or representing a trustee to try to stop the music until such time as you can get a judgment and keep the property in effect frozen during the course of litigation. Very interesting concept. I had never heard of it before.
Jim, I haven't seen that in a bankruptcy case. I did see that. I had a client that was that happened in a federal district court in Florida within the last couple of years, where there was a trust that had been set up, and there was allegations that it was a fraudulent transfer. It was done for estate planning purposes, and the bank filed a district court action against the guarantor and the borrower and named the trust. It was actually, I think it was actually an LLC, to enjoin it from transferring any further assets, and it was pretty effective. And the judge did grant the TRO. He did turn into a preliminary injunction, and ultimately the case settled. They brought us in to help do the work out and negotiate the settlement, but I haven't seen that in the bankruptcy court, though.
Another question?
I was just going to note there was also an accounting requested in that lawsuit as well, and that was one of the reasons why the court distinguished Grupo Mexicano and said that the prejudgment attachment was actually available to the litigant, to the trustee. So that's one thing to consider. If you could add a 542 and ask for accounting at the same time, that may be a way to go after it. I wanted to ask a quick question. As long as I have the microphone, I'll go ahead and ask a question. On the issue of extending the statute of limitations under the emergency motion, Neil, that you were talking about, did no one appeared to oppose that?
Well, I don't remember how many hours notice there was, but yes, nobody appeared.
Okay.
I don't know if you heard what the actual situation was that the trustee was appointed interim trustee late on a Friday afternoon. Monday was Labor Day, and Wednesday was the 2-year mark. So it all happened very, very quickly. And as potentially you could have tried to reconvert it to an 11 and deal with it that way, but everything was fraught with problems with notice. I mean, there was just no way around it. So we all did the best we could under the circumstances, and especially the judge, especially the judge. And but yeah, it's you know, you're always going to worry about notice and due process, but it is what it is. When that's what was handed to the trustee.
So, and no claims were ever brought, so that no one really tested whether or not the court had the power to do exactly that. You
know, I was all right with that. Because the last thing I wanted was to spend a lot of time litigating, and then maybe a higher court would say, no, you know, you didn't have the right, and then you've wasted all that time. But it was the trustee's investigation. He determined there was nothing to pursue.
Understood. Nancy, I've got one for you as well. I'm noting some questions I went through here. I'll ask you real quick. In the Chapter 13 context, if the Chapter 13 debtor proposes a plan and says, I'm going to allow all these claims, or is there a res judicata issue that you see where there's plan confirmation, there's no retention of claims, there's no provision for pursuit of claims? Typically then, the Chapter 13 trustee and the Chapter 13 debtor do not pursue anything thereafter. Has anybody ever tried to do that, where there's res judicata or that kind of thing that implicates or is implicated?
We're going to have a panel on this. We're going to have a panel on this at the ABI, the Southeastern Conference, if you'd like to attend.
Well, there was a recent decision, I thought, somewhere in the country in the last 6 weeks on this issue.
Yeah, it's becoming a hotter issue with the effect of res judicata and what can you reserve. Our plans actually in the Northern District, our plan has a provision, at least dealing, I can't recall exact wording, but it reserves the right to object to a proof of claim post-confirmation. I know that was an issue for Camille Hope in the Middle District of Georgia when she attempted to avoid a lien post-confirmation, and they did not have any type of provision for her to take that action post-confirmation of a plan. And she was aware, I think in that particular case, she was aware of the avoidance. I think it was actually a motion to avoid lien under 522, but she was aware of it, and so she was precluded from pursuing that, at least at the bankruptcy level. So I think it's an issue typically, I'm sorry? At the 11th Circuit, yeah.
Acorn case, in Ray Acorn.
In
that case, the plan allowed the claim secured.
Right.
Well, that's the res judicata issue.
There was no preservation, though. Like
right.
Our plans, for instance, could have a treatment, it could have, and then the debtor could discover, let's say that the plan treated it as a general unsecured, or it had some type of treatment within the plan, and then later discovered that there was a valid reason to file some type of lien avoidance. You would still be able to in our plan because we reserve that in the plan. We have had issues come up post-confirmation in the situation where, because the proof of claim was filed post-confirmation, where we discovered that a mortgage wasn't properly perfected. And I have not had the creditor raise that as an affirmative defense of a res judicata. Not saying it's not coming.
Well, and there's a whole body of case law in Chapter 11 on this issue, where the retention of claims, res judicata, law of the case, estoppel all flow through. In fact, a lot of Fifth Circuit decisions, Your Honor, on this area as well, because I'm speaking on this in a little bit in the Norton thing. And I was curious as to how 13 works. It sounds like it's kind of moving in that direction as well.
And I think it's going to depend upon how the plan is structured and what you have. This is something that's, just throw this out for anybody that's, especially Chapter 7 trustees or people that do real estate, and this deals with Liz Pendens, that in the state of Georgia, it was just the real property section of the State Bar of Georgia now has pending legislation in this legislature, because there was a case that went to, I believe, the Georgia Supreme Court, may have been the Court of Appeals, where the creditor filed a lis pendens during an arbitration. It wasn't a lawsuit wasn't filed, it was an arbitration, and it was the court determined that that was not appropriate. And so the real estate property now has pending legislation to enlarge what is the definition of an action, to include arbitration and mediation, so a lis pendens can be filed even if there's a mediation and arbitration pending. So if you're tracking any kind of Georgia legislation, and you want to support that legislation, you can contact the real property section.
In any case with the, whether it's a defective mortgage or potentially fraudulent transfer, I'm always worried about unauthorized post-petition transfers, and so I always record the bankruptcy notice on the real estate records. It's not a lis pendens. It doesn't come under that statute. And 549C actually gives, under real estate transfers that are unauthorized, post-petition, gives a bona fide good faith defense unless the notice of the bankruptcy is recorded on the real estate records. So I always record it. When I file a lawsuit, I upgrade that to a lis pendens. Yeah.
All right, we are going to break immediately into the reception. If you step out the doors, the reception area will be to your left. And we'll hear some remarks from Judge Stewart. Thank you. All right.
Yeah, I know they do. We had a lot of